So these are important cases. I'm told that we probably won't get a decision on them until the end of the year at the appellate court. Both have been decided in favor of the towns for now. Understand that this is probably going to have to be resolved at the legislative level and the governor at some point in time anyway. But I want to make it clear that if the state, and I don't say we, but if the state allows localities to zone out, there will be no oil and gas investment in the state. It's as clear and black and white as that. And the Dryden case really points that out. They spent $5 billion in leases, only to find that the locality then later on zoned them out. So that's a significant problem that needs to be overcome. The casing and cementing guidelines, if there's anything I want you to leave with today, it's this, that we developed casing and cementing guidelines back in the 1980s, calling for redundant protection of the fresh water of the state. In other words, 2 strings of pipe, 2 sheets of cement for every single well drilled since 1980. These conditions have been relatively unchanged for 30 years, and we have never had a well that has significantly impacted the groundwater of the state of New York since at least the 1980s. Okay? So when somebody tells you that, well, over here in Pennsylvania we had this problem, we had that problem, it didn't occur in New York. It's never occurred in New York. And just to make full circle, Pennsylvania adopted what we've had for 30 years in December of 2010. So it's no wonder that they had a series of problems with gas migration, with impacts to groundwater. We've never had the problems. Come on, baby. All right. This, and I won't go through this diagram, but you've kind of seen it on the slide. Here's what I'm talking about. The water here is at 500 feet. Formations down here at 5,000 feet. And John's going to talk about this, but this is what we do. We protect the fresh water of the state of New York. And we have drilled 10,000 wells since 1980 with 0 problems. 0 problems. So again, there's no reason and no justification for, and by the way, the new requirements even increase the casing, put another string of pipe for the high volume hydrofracking wells as well. We also at the time, we also at the time developed aquifer conditions. And these aquifer conditions call for a 3rd string of pipe. So there's 3 strings of pipe. So in an aquifer, the Jamestown aquifer in particular, you have water, cement, pipe, cement, pipe, cement, pipe, wellbore. Okay? And we've never had a problem in the Jamestown aquifer drilling through that. And we've drilled hundreds of wells, maybe even thousands of wells through the Jamestown aquifer since really the turn of the century. One other important point is that if you drill a well through an aquifer, if you're going to do that, DEC has to be on site when that cement job occurs and has to witness that cement coming back to the surface. we have been doing this for 30 years. This is not new. And we've had literally no lawsuits on any well drilled, any state lawsuits at least, on any well drilled in the state since 1984, when the city of Jamestown actually challenged our aquifer conditions, and their own consultant concluded that we had at least as stringent, probably the most stringent aquifer conditions in the nation. And this becomes important when we talk about drilling in the aquifer under the SGIS. So the State Environmental Quality Review Act came about in the late 1970s, and the Division of Mineral Resources in particular, eventually all the divisions were asked, well, how are you going to comply with this? So we came to the conclusion that the best way to comply with seeker and to continue to issue permits without having to do an environmental impact statement for each one of those permits was to undertake what's called a generic environmental impact statement. looking at all of the impacts of a generic well, et cetera, et cetera. And if you met the conditions, if you met the thresholds, you could get your permit and you could go on and drill. So that's what we did, and we started in 1988 and finished in 1992. And so the generic environmental impact statement has stood really since 1992. That included, of course, the casing and cementing requirements and all the other conditions that we had already negotiated with the industry. By the way, those negotiations were tough with the industry. We asked the industry to help us develop a system and to protect the fresh water. So we sat down with them, and there was a lot of hair pulling about those things. In 2008, there was some very good legislation passed in 2005, 2008. I had nothing to do with this, but basically the state was trying to space wells to get away from redundant hearings, particularly in the Trenton Black River Formation. But in the process, they spaced Marcellus wells. But the problem was that when the governor, this was Governor Patterson, when he signed the legislation, he said, well, you really didn't cover this kind of drilling, horizontal drilling, and these large amounts of water used for hydrofracking in the 1992 GEIS. So he said, you need to go back and supplement the generic environmental impact statement, which is called a supplemental SGEIS, Supplemental Generic Environmental Impact Statement. That's what we're doing now. And that is the correct approach to seek. So what's changed from 1992 from the old way we do things and the way we've done things? Well, I told you that we're drilling horizontal wells now, and you'll see how much more beneficial that is. But it's great, huge amounts of water supply for water needed for hydrofracking operations, much greater than millions of gallons versus the 80,000 gallons that's in the 1992 GIS. And of course, it's also recycling and disposal of these oil and gas field wastes, overall development of the resource impacts to municipalities. In other words, the scope of things has changed a bit. So these are all things that are being addressed in the SGIS. But I want to be clear about something. It's not about hydrofracking per se. Hydrofracking is not new. The only thing that's new in this process is a horizontal well, which, by the way, has no more environmental impact than a vertical well, and the large amounts of water. Hydrofracking is not new. We've been using hydrofracking in the state. Well, you can see here for granite mining, we've been doing it for water wells. We've been doing it for all the Medina wells since the 1960s. All the Barnett wells in Texas, probably 14,000 now, have been, these are high volume horizontal wells. So we're not talking about, they've all been hydrofracked. We're not talking about something that's theoretical here. This is actual, this is what's happening. And in our country, we've drilled over 1 million wells and hydrofracked over 1 million wells since the 1940s. I mentioned the IOGCC, and I'm still a governor's appointee. He doesn't know that, but I'm still a governor's appointee to the Legal and Regulatory Affairs Committee of the IOGCC, and I was the governor's representative for 20 years or so. No one during that time ever raised an issue, any regulator ever raised an issue that hydrofracking could impact the fresh water in all those years. It's just not really possible. And DEC has said that they've never, I don't know if this comes from the 92 or the SGIS, but basically there's never been a documented instance of a well that's been hydrofracked impacting the fresh water. Spacing, I want to talk a little bit about spacing because that's a kind of a misunderstood point. Spacing is just the amount of acreage that's necessary for a unit to drain an area. For example, a Medina well, you have a 40 acres, a vertical well, you have a 40-acre unit. For a Marcellus well, or a Marcellus vertical well, the acreage is 40 acres, vertical. okay? But the technique is really now horizontal, and I'll explain to you why that's much more preferable. So, our law says you cannot drain your neighbor's property, protection of correlative rights, you can't leave out properties between different spacing units. In other words, stranded acreage. DEC will make sure that everybody gets put in a unit. And it doesn't, these spacing units, of course, don't respect municipal boundaries, which is another reason why the geologic interpretations need to be done at the state level for spacing and not on a zoning by zoning basis in the towns. And this is the legislation I talked about in 2005 and 2008. 2005, they spaced vertical wells, and in 2008 they said, well, wait a minute, we need now to space horizontal wells. So this is what led to the SGIS. And in a horizontal well, now you can drill horizontally, but but the drainage area is 320 feet from any point on that pipe. So if you just think about a spacing unit now for a vertical well, instead of being for a horizontal well, instead of being a square for a vertical well, you're now looking at a rectangle. In other words, going this way and proceeding. So the big secret here, one of the best things about this Marcellus drilling, and John will speak again about this, is that it has a very, very small footprint. If we're talking about a 4 to 5 acre drilling pad, you drill multiple wells from one location. These horizontal wells can have much greater recovery. It is smaller footprint, landowner friendly, farm friendly. You can put the drilling pad at the end of the, first of all, you can negotiate with the oil and gas company, put it where you want, put it near access roads, put it on the end of the property, let's say. And then you can drill your wells from the end of the property through and drain the entire property. You could drain 640 acres, which is the maximum spacing unit for the state of New York. So think about that. If we had vertical wells, we would have drilled 16 vertical wells in that same 640 acres, probably disturbed 2 acres per pad. So you're talking about a disturbance of 32 acres to drain that 640 acres versus 5. Excuse me. In Pennsylvania, they're putting two 640 units back to back. And they're actually draining, with that 5 acre pad, draining 640 acres in this direction, 640 acres in the other direction. So they're draining 1,280 acres with a 5 acre footprint. This is kind of what it looks like. Now let's talk about, very briefly, what's new in the September 2011 SGIS. There are a lot of different things that were added. Most notably, the prohibitions and setbacks. There are a number of prohibitions and setbacks saying you cannot drill in an aquifer, you cannot drill in a 100-year floodplain, you cannot drill on state lands, you have to set back miles from the New York City reservoir, you have to do this, you have to do that. And so we can't go through all those things, but the fact of the matter is that these are problematic. And when they released the SGIS on Friday, they said that 80% of the land in the Marcellus was still available. And I knew as a regulator, I knew that once you put down a setback or a prohibition, you create consequences. You create some unintended consequences, and I knew that couldn't possibly be right. So on Monday morning, they said it was 85%, they said it was 85% available on Friday, 80% available on Monday. So they already concluded that there was a 5% difference. I knew that was incredibly high. Still, there was something wrong. So what's happened here is that that by imposing these restrictions and setbacks, they have removed the drilling efficiencies from the process. Just like I told you, we could drill the 640 acres and drain that 640 acres. Now they're segmenting parcels. And by the way, the companies went back and looked at some of their acreages, and it's now 40 to 50% available, not 80%. So it's a huge difference. They've devalued our landowners' royalties, they've devalued our landowners' bonuses, they devalued the entire process by imposing these setbacks and prohibitions. In addition, and most importantly, they've created a situation where you may have to segment and go around people and go around things, which means probably there'll be more wells drilled, which means more environmental impact. So they've completely reversed they've reversed the situation and trying to do what they thought was the right thing. They've actually created a bigger problem. And there's also a great deal of regulatory uncertainty within the process. It's very difficult to figure out how to get a permit. And if you look at, by the way, you should look at Appendices 6 and 10, which pretty much have all of the requirements that are necessary to get a permit. But within the document, there are multiple points of approval internal to DEC, which is not the way we generally do business at DEC, and also external approvals with the Department of Transportation and Department of Health on NORM, naturally occurring radioactive materials plans that need to be filed as well. So the process itself is going to take a long time to get through the regulatory process to even get a permit. You know, maybe on the order of a year or 2 years. At least they need to straighten this out. So where are we now? Well, the comment period closed, as you know, the end of December. The DEC is, there were hearings held in the Marcellus areas and in New York City as well. There's discussions continuing with DEC on some of these issues and the governor's office. I don't know if anything is going to change, frankly, but that's happening. You can expect that there will be lawsuits on the SGIS once it's issued. Probably a flurry of local zoning laws put into place before the SGIS comes out. And we're probably looking at no drilling until the end of 2012 at the earliest. That's probably optimistic, although you might see an announcement about whether we're going to go ahead or not going to go ahead, but the details won't be finalized, which, by the way, is a finding statement, which says that we can drill it and we can drill the Marcellus, it'll be done this way, et cetera, but that's the finding statement. That's the end of the generic supplemental generic environmental impact statement process. So I made a presentation to Business Council in 2009, and I said that Marcellus natural gas development may be the greatest economic development opportunity in depressed areas of the state that we will see in our generation. And I think that's it's even more important now. No environmental compromises. We never compromise anything. We're not going to do that. We need to provide our upstate New York with natural gas. We can do it in our backyard. We can have natural gas and water. Manufacturing is going to come back to this state if that happens. And the landowners, of course, deserve to share in the wealth. And there is my contact information if anybody wants to contact me. Thank you.
Thank you, sir. I'll try not to